Today, I want to talk to you about an issue that we are currently seeing a lot with our clients in this era of COVID-19 and the consequent lockdown triggered by this pandemic. Quite a lot of our clients want to terminate contracts, want to break free from the contractual obligations that they had taken prior to the pandemic, because they can't benefit from the services or the products that the other party was contractually obliged to provide them with in exchange for money, remuneration, etc., etc. So, for example, quite a lot of our clients want to terminate their lease agreement because their shops are closed or their co-working spaces are closed, so they can't attend those premises. So, of course, they don't want to pay the price for the rent. That is an example. We're also seeing, and that is not triggered by COVID actually, but we're also seeing with Brexit issues and red tape that quite a lot of UK-based businesses cannot make deliveries of products anymore now to continental Europe, the 27 member states of the European Union, Northern Ireland, for example, and they are saying, stop, we have to stop doing deliveries in these places because we don't have the staff to actually fill out all the documents and make sure that the red tape is taken care of. So we just have to stop deliveries in these places. So when they come to us, our clients, they're asking, so is this force majeure? Can we actually invoke force majeure with the other side, with the other party, in order to terminate the contract? And force majeure is a legal concept which is defined as follows. When an event which is outside the control of the parties occurs, then it means, and if such event triggers the impossibility by one or both parties to execute their legal contractual obligations, then a force majeure event occurs, which means that the either the contract is terminated or it is put on a standstill. And force majeure is a French concept, force majeure, and it's, I suppose it's been basically adopted by the Anglo-Saxon world. The issue, though, that we are seeing is that a lot of contracts which were drafted and executed prior to the COVID-19 pandemic do not contain such force majeure clauses. Usually force majeure clauses, by the way, they relate to, acts of God, very strong riots, wars, acts of wars, fires, very strong fires, very strong floods. These are examples of force majeure cases. And now we could even add a pandemic. So a lot of lease agreements, for example, with the likes of Regus or other co-working spaces, they do not set out any force majeure clauses, which is, when you think about it, crazy, but it is true. And it's very difficult for our client as well who are all, of course, professionals. They are not consumers, so they can't be treated as, a much weaker party because they are consumers. No, they are actually professionals, be it company directors or, creative entrepreneurs working in a self-employed way, but they are all professionals. So they can't really invoke in front of the likes of, Regus or the counterparty. They can't say, well, we are consumers, so we are weak, so you presented us with contract which was already drafted, which in any case we couldn't negotiate, and it was, a take it or leave it situation, but because we are consumers, we are protected, and therefore, you have to comply with consumers' law and terminate that contract, which is in breach of consumer protection law. When a case of force majeure occurs. So in this case, as I was saying, our clients who are all creative professionals, they can't invoke that clause because they're not consumers. So what do if, in addition, there is no force majeure clause in the contract, in the professional contract with the other professional party that provides for a case of force majeure? Well, it's complicated, I must admit, but now there is more and more a body of case law which has been basically appearing in France as well as in the UK, in England and Wales, because of course you are not the only one being affected by this issue. Quite a lot of companies and businesses are being affected by this issue, which is that they haven't been able to go to their work premises for months now because of the first lockdown, the second lockdown, another third lockdown in the UK, and potentially a third lockdown in France also coming soon. So these businesses have started litigation in order to have the judges decide whether COVID-19 was a force majeure situation. So what's been happening in the UK, for example, recently, is that the UK courts have decided that the insurers had to actually pay for the cost of the losses incurred by the insured businesses because of the fact that they were unable to attend their premises of their rented premises and make sales because they can't sell. So the UK courts have forced the UK insurers to actually treat the COVID-19 pandemic as a force majeure case, as a case which is protected by these insurance contracts, and therefore these UK insurers will have to pay some damages and some funds to these insured businesses in the UK. So that is an example of this body of case law which is appearing around the world, I suppose, but in particular for our purpose here, for the UK, for England and Wales, as well as in France. In France as well, French courts have started to decide and to put the conditions under which COVID-19 can be treated as a force majeure case of pandemic, and therefore a valid cause for termination of a contract. So on a pragmatic standpoint, what's going to happen is that if you have a contract that you wish to terminate, and because of force majeure, because of the COVID-19 pandemic, and if you don't have a force majeure clause in your contract which provides for such case of an act of God or a disease or a pandemic, etc. happening, then you and your counsel, I strongly suggest that you take counsel in this instance, you and your counsel have to explain and to show and to demonstrate to the other side that despite this lack of reference to a force majeure situation in the contract, the force majeure situation does exist factually, and therefore the contract needs to be terminated as per the new body of case law which has been published recently by the court in relation to COVID-19. And it's going to be a lot of negotiations. If it works, it's fantastic, and then the contract is terminated. If it doesn't, then you have to speak to your counsel again and potentially have to litigate to obtain full satisfaction in terms of terminating the contract and stopping having to make payments for services that you cannot benefit from anyway because there's a lockdown and you can't go to your work premises. So good luck with that, and don't hesitate to come back to us if you want some advice on this particular fraught point at the moment. Bye for now.